right, well, it looks like everybody's had some coffee and the treats are all gone back there, so that's awesome. I am delighted to start this series on getting our house in order. I want to thank Kathleen, our office administrator and business manager, for helping me get this in place. Oftentimes, we look to help folks in this area, and I really see it as a way to be a good steward of what God has given us, both financially, physically, spiritually, our abilities. So we will be addressing a number of subjects which are there in the beacon and have been there in the publicity. Today, I'm delighted to have Phil Havers, who is an attorney, a member of our congregation, share some really important things around estate, finances, getting our house in order in that regard. And I know I've had a number of you say you're really looking forward to this presentation. So again, let's thank Phil and welcome Phil to helping us out.
Thanks, Steve. So I'm here to talk, and you're here to listen and hopefully interact with me with questions about the extremely fun topic of estate planning. I know this is not something people enjoy doing, but I think it's incredibly important. I'm amazed by the number of clients I have, and I'm an attorney, as Pastor Bill mentioned, down in Silverdale. We've been here since 2003. But I have a number of clients who come in their 60s, 70s, 80s, and even in their 90s who say, I don't have a will, so I think it's time I get it. Conversely, I also do have a lot of people coming in their 20s and with young kids who say, I need a will, because I also want to make sure that my kids as minors are taken care of. So today what I'm going to do is kind of go through estate planning. What is estate planning? What can you do with it? Why is it important? What are the documents? And what happens if you don't do it? There are, some of you saw the slide earlier, 2 truths for today. Everybody dies and nobody likes paying money to lawyers. So the second one is, it's one of those, I also do contract work, and I will tell you, I get a lot of clients coming in after they've signed a really bad contract because they haven't done the work up front. And they say, get me out of this contract, or what do I do now? And you end up paying $40,000, $50,000 to a lawyer in litigation because you didn't have someone review it up front. So same thing, if you don't have a will, if you don't set up the proper documents, because it's not a fun thing to think about, you kind of shove it off, I have plenty of time, until you don't, your family ends up dealing with a lot more headache, emotion, financial, everything, and we're trying to avoid doing that. So some of you may be very familiar with a lot of the terms, others do not necessarily know much about it. So I'm going to assume everyone knows nothing. I don't mean to talk down to anyone, but I get people saying, what's a probate? What is probate? And I think we'll probably start there. Probate is just the process by which, after you pass away, your estate gets handled. Creditors get paid, heirs get the benefits, and assets get sold, that sort of thing. We're going to also down the road in this presentation talk about trusts, because one of the questions I get a lot is, how do I avoid probate? Chances are you've either come from California or know someone who's come from California. California is a nightmare. The lawyers take a percentage of your estate. By statute, probate has to take 3 years. And so it doesn't matter if you're worth $5 or $1 billion, everyone has a trust. That's not the case in Washington. Washington, probate is pretty simple. It can be as streamlined as it needs to be. And really the only major hurdles are creditors' claims and then making sure that your heirs aren't fighting. Because if the heirs fight, then all bets are off and you're in litigation for years. So that's the situation. So the first thing we're going to talk about are wills. If you do not have a will, what happens? Basically, your estate goes into intestacy, and you have an intestate probate. What that means under Washington law is that there are strict things that happen. If you're married, the community property will go to your spouse automatically. Separate property, half goes to spouse, half goes to kids. You don't really have control over that. If you had wanted to give money to a charity, you don't get to do that. So having a will is very important to ensure that what you want actually happens, because otherwise it's going to go by what the state of Washington says. And it goes from spouse, and if you don't have a spouse, it goes to your kids. If you don't have kids, it goes to parents. If you don't have parents, it goes to siblings, and then cousins, and ultimately, if no relatives, the state of Washington gets the money. So we want to avoid that, right? So the main documents are a will, community property agreement, durable power of attorney, healthcare power of attorney, healthcare directive, and that's the one that can bake your noodle a little bit when you start thinking about the things. That's the document, and we'll talk about that, that tells your healthcare power of attorney and doctors what you want at the end of your life when you're no longer competent. Those aren't fun conversations to normally have. You know, if you start to get sepsis in your leg and the doctor says to your healthcare power of attorney, we may need to amputate or they're going to die. Is amputation a dinner time conversation? Probably not, but having a healthcare directive at least gives guidance on what to do. And then last question is the issue of trust. And I have a question mark there because, as I mentioned, you may or may not need it depending on what your goals are and that sort of thing. We'll talk about that in a second. So wills. Get a will. They're simple. They're not expensive. They ensure specific bequests, and they minimize future disputes. People who are younger with younger children, that's where you also get to say, if I die before my kids reach X age, here's who I want to administer the, put it into a children's trust within the will. Here's who's going to be the trustee. Here's when they get it. Because if you don't have a will and you have minors and they turn 18, they're going to get it. And I like to think my parents are here and they'd probably, I hope, vouch for it. I was a responsible kid, but if I inherited a couple $100,000 when I'm 18, I would have bought a Lamborghini. I just flat out would have bought a Lamborghini. So you don't want them to do that. You, as a young parent, want to put things into trust. If you have children, whether adults or minors, who have special needs, whether it's a mental disability, drug issues, that sort of thing, you want to put your estate into a special needs trust, designating who the trustee is for a number of reasons. One, you don't necessarily want your child to have control over the money. That might be an absolute disaster for a myriad of different reasons. The other reason is if you are relying on Medicaid, for example, for payments. The minute they inherit that, they no longer qualify for Medicaid. By putting it into a special needs trust, you can, it's not their money, it's a special needs trust. So make sure you have that in there. So those sorts of things happen. And frankly, I've had clients who say, my adult kid who's 50 is an absolute disaster when it comes to money. There's nothing wrong with them per se. They just are a disaster. Put it into a special needs trust, and they will never get control over the money. Even though they're 50 years old, normal, functioning adult, parent just wants to kind of micromanage things from the grave. That's what you do. Whether it's right or wrong, who knows? One other document that is very, very helpful is a community property agreement. Community property agreement basically says what's mine is yours is mine. The benefit to this in Washington State, we are a community property state, but you can still hold separate property in Washington. And if you don't have this, when the first spouse passes, you will have to open probate. But yes?
So if you own a joint, you don't have to worry about this, but if you have a separate ownership of
Well, yes and no, because, so, let's say you have a house, and it's owned jointly, and you die. If you don't have a community property agreement, you have to open probate. Because if you go to sell your house in 5 years, the title company is going to say, okay, you're signing the deed, who's signing it on behalf of your spouse? Well, she died.
Right.
Well, someone still needs to sign, because she may have said, I want it to go to my kids or something.
Right.
If you have a community property agreement, there's actually statute, WAC regulation that essentially says, if you have a community property agreement, when the first spouse dies, we record that in the death certificate on title to the property, and you don't have to open probate. So it helps save. So probate itself in Washington, by the time all said and done, if it's a simple one, you're looking at a couple of $1,000s. That includes things like publishing notice to creditors, that sort of thing. It's not, as I said, the massive undertaking it is in California. But still, you don't want to have to do that out of the gate. So community property agreement certainly helps with that. Now, if you have a blended family, second marriage, something like that, you may want to retain some of your separate property because you're giving it to your biological kids. You don't want it to go into the estate generally, that sort of thing. So there are definitely reasons why you may not want a community property agreement. Similarly, and I guess I'll give it this caveat because I'm a lawyer, is this is a general broad brush presentation. There are going to be clear, specific issues based on your individual estate. Everybody gets 2.2 million roughly exemption in Washington before estate taxes kick in. People always say, how do I protect against estate taxes? If your estate is worth 2.193 million or less, when you die as an individual, you don't pay estate tax. As a married couple, you're entitled to about 4.4 million. So you're good there. If you start getting above that, in your will, you can do various things, marital trusts and all that. So don't, following this presentation, take good notes and then run off to LegalZoom and do your will, because you're going to get what you pay for, and what I'm telling you is broad brush, and it may not apply to your situation. So before we move on from wills, I guess anyone have questions about that with wills? Pretty simple. If you do try to do a home will or something, it's got to be witnessed by 2 witnesses and notarized. Oftentimes they get people on the back of a napkin. It doesn't work. And I say this, but it's genuinely, it's what happens. Yes?
It's just one of curiosity.
Wait, so people can hear your questions.
If my will is 40 years old, it's still good, right? I don't have to do anything to that.
Wills don't expire. That is the nice thing about it. I do tell clients, pull them out every 3 or 4 years. They were written based on your situation at the time. You know, if you've named an executor who's passed away or moved to Abu Dhabi or something like that, you may want to pick someone else. Similarly, if, you know, when I do them with children's trusts and all, and then the kids outgrow it, you don't need to redo the will, because it basically says after they turn 25, 30, whatever the age is, then they get it outright. So you don't need to amend it based on that. But, you know, if you inherit a bunch of money and you just have a simple will, and now you may be pushing at that estate tax threshold, you may want to revise it to put it into marital trust.
Yeah, I think it had to do with children, where, you know, we had a designee for our
Like
children.
a guardian.
And they're all
yeah,
grown adults now, but they're still in the will.
Yeah.
Okay, thank you.
Great. Any other questions about?
Thank you. From my own experience, I would say take a look at your will. I made mine 2 years ago, and I've already had changes, so tomorrow I have an appointment to get my will updated.
And then one back here, please.
I have a list of some things, you know, that I want. I mean, I have a will and all that, but I have a list of some personal items that I want family and friends to have. Excuse me. And I had it witnessed by a girlfriend, and you said something about 2. Do you have to have 2 witnesses for that?
Well, so in my wills, I specifically say that if there's a list of personal property items that's attached to the will and signed by me, it doesn't even have to be witnessed, that can govern. And if you either don't do it, or you make a list initially and then want to add to it, change it, tear it off, sign a new one, and go from there. The key is you want something within the will document itself that references that list, because if your will just says, you know, my daughter gets everything, and then this list is something totally different. I mean, internally within the family, I mean, so much is family dynamics. So if in that example your daughter's like, no, I want to honor what mom says, fine, she can do that. I mean, everything technically goes to her, but then she parses it out. If you get a daughter who wants to be a stinker and says, that's not gonna happen. One of the other big things in a will that I've experienced, I've litigated this, it wasn't a will that I drafted, was issue of joint bank accounts. Where the bank, if you put your daughter on, or son on a bank account for convenience, you say, look, I'm 85, I don't wanna remember to pay my cable bill, so I'm gonna put my son on to pay my utility bills. Even if your will says, my son and my daughter get everything equally, the bank's gonna go, he's on the account as a joint account holder. He could be a stinker and go, that $50,000 is mine, then we divide everything else out 50-50. So in the wills that I have, I just say, any joint accounts I have are convenience only, and it's not my intention that he or she inherits. My story on that is I had a client whose granddaughter, well, it was his niece, I guess. Grandma had put granddaughter on the account to help pay bills. There was $60,000 in the account. The will expressly said, I want my granddaughter to have $3,000 because I love her. So clearly grandma wanted her to only have $3,000. Grandma dies, the will does not contain a convenience account clause, and granddaughter decided to be the stinker and take the 60 grand. Her mom supported her in this because, hey, that's our side of the family, and the son, my client, objected, and we ended up in court, ended up settling, but it was one of those things of both sides spent $10,000, $15,000, $20,000 in attorney's fees. So you want to just kind of address those sorts of issues.
Okay, hold on, quick comment, hold on.
We're coming.
We'll go here and then we'll go there. Yeah.
I was just wondering if you could explain, well, you can answer her question first, but just a little bit more about durable power of attorney.
Yeah, I haven't even gotten there
Oh,
yet.
it's coming.
That's coming next. Before we get moved on from wills, I want to answer another question.
Do you have to distribute to your children equally?
No, but if you're gonna omit a kid, you want to identify them and expressly say, it's not I'm expressly disinheriting Bob because it's my intention that Bob gets nothing. It's kind of a harsh paragraph, really. But no, if you want to give 80% to one kid and 20% to another, absolutely, you can do whatever you want.
Okay, I was told by a friend that you have to give $1 to the child.
Some lawyers say you do. I put in the disinheritance clause. I also do put in a provision that says if anyone challenges my will, they get $1 if they win and nothing if they lose. And that cuts down on challenges. So don't do that.
In other words, be specific in all of this.
Yeah.
Okay, very good. I want maybe one more, and we'll also have some time at the end.
Yeah, we'll do it.
Yeah.
What about wills and power of attorneys done in another state?
Strongly recommend you get it done here. Redo it. Not that they're invalid, but if all of your assets are here and you die here, we have to open probate here. And if you send me as a lawyer into the court to explain what a Delaware will says and what the laws of Delaware are to a Superior Court judge in Kitsap, both the judge and I are gonna be like, I don't know. So strongly recommend it. If one question comes up, if you do have an asset in another state, like Arizona, you've got a condo, you snowbird, what do you do with that? That may be a situation where you would open a probate here and do an ancillary probate down there. Now, if it's a state like California where you have your asset, put it in a trust. And similarly, you can put the asset down there in a trust to avoid probate, like in Arizona. But Arizona, from my understanding, is more like Washington. It's not that scary. It's not that big of a deal. So it really is state by state. So bottom line is, if you have assets in another state, talk to a lawyer in that state about what the probate process is like. I just did one to avoid probate in Oregon, set up a simple trust here in Washington, kept everything else out of the trust in Washington because we didn't need to spend all the money to quit claiming everything here. But we put the Oregon property in, they're having the Oregon lawyer do it there because I can't practice law in Oregon, into that trust, just so when they die, you don't have to do a second probate down there. Yeah, sure.
Very helpful.
Okay, powers of attorney.
Yeah. We'll
Now-
come back. Remember your questions if you.
Yes, powers of attorney, it was amazing to me over COVID. I said this was the most important set of documents over a will even. Because people were coming to me because they weren't necessarily scared they were gonna die because of COVID, But if I'm on a respirator because of COVID, who's making the decision when to pull the plug, what sort of treatment? I can't necessarily communicate that. So the estate planning practices here in Kitsap and probably around the country went through the roof during COVID. But you want to have powers of attorney. Now, powers of attorney die when you die. I have clients coming to me saying, oh, I didn't do mom's probate because I had power of attorney when she died, so using my power of attorney, I just distributed everything out. That's illegal. Don't do that. You can't do that. Your authority as power of attorney dies when the person who granted you the power of attorney also dies. So the durable power of attorney is general. That's finances, that sort of thing. Obviously, healthcare power of attorney is for that. I like to make them effective immediately. Old school kind of powers of attorney say it only becomes effective upon incompetency. I don't like that for two reasons. One, sometimes you're just out of the country. You're not available. It's not that you're incompetent, you're just not here. Or maybe you've got the flu and you don't want to go and get your test results at the doctor's office, so you want to send, your daughter who has power of attorney. You're not incompetent. And to be declared incompetent, it's got to be a court order, doctor certification. I mean, there's specific things. It's not just, mom's in bed. There are specific things. And then, the other big thing is when you start to become incompetent, start to get dementia, you don't know that you're often getting it. And it turns into a really big emotional thing for both you and your family to have to be declared legally incompetent in order for it to kick in. So to avoid that, make it effective immediately. You're not giving any rights up. You're only giving someone else rights. Now, does that mean the durable financial power of attorney you designate can access your bank accounts and could theoretically drain them? Yes, it does. If that's the risk, don't name that person. And I say that tongue in cheek, but people are like, well, he's had financial problems, but he's a good boy. Don't do that. But these are the things that are very important during your life. This gives your kids, if you're on a joint account, the bank will talk to the joint account holder. But if you've got questions about a retirement account or something like that you want your adult child to start asking fidelity about or something, they won't talk to you if you don't have a power of attorney. So get it done. And especially the healthcare power of attorney, this starts to really come up on medical decisions. Because if you don't have this, and you're lying there in a coma, and the question is, do we pull the plug or not? They can't make the decision. They've got to go and get a guardianship in court. It can cost a couple $1,000. Meanwhile, there's a question of who's going to serve, who's the one. If you have kids and one says, keep mom or dad hooked up to the machine because maybe they'll come out of it, and the other kid's saying, don't do that, they wouldn't want to live this way, who's going to control?
Go ahead. Oh, you have a question?
And while they're giving you the mic, the other big thing, I always have clients saying, I want to name both my kids, whether it's on the will as executor or on power of attorney. Do not do that. That's a great way to end up with the Terry Schiavo situation from Florida, which frankly started a lot of this, where the husband wanted to do one thing, the parents wanted to do the other. She's in a coma, bad brain damage, and they were in court for years. If one kid says, take mom's money and put it into cryptocurrency, and the other one says, put it under a mattress, neither are necessarily great ideas, but they both have equal authority to make that decision, and now they get to fight it out. And they both have the legal right to make the decision. So make one, doesn't mean that they can't talk to the rest of the family about, how we manage mom or dad's health care. Hopefully they will, but someone has to be the captain of the ship.
How does this affect the DNR, do not resuscitate?
So that's the next document, but the healthcare power of attorney is the one that effectively is going to make those decisions. You have a healthcare directive that they will follow. Now, the healthcare directive really is a quasi-legal document. It's supposed to convey your intentions, but let's say you are in a coma and your healthcare directive says, only give me artificial nutrition for 14 days, okay? But on day 13 of your coma, you kind of start flapping your arm a little bit. They're gonna go, keep them on for 5 more days, notwithstanding that, because there's a change in the medical condition. So it's not a black and white thing. Now, it does give, though, your healthcare power of attorney the legal authority to say, he doesn't want to live like that, now we're going to disconnect and do that. Have a couple, yes?
So I was an ICU nurse for 10 years, and even though there's a power of attorney and healthcare directive, know where that is, because we still have to take care of you and do everything we can till we get that in hand.
Yep.
And let all your children know your wishes, because people have estranged children they haven't seen in 7 years, and all of a sudden, you know, Jane flies in and like, no, do everything, and
Right.
they're like, no, this is
Yeah.
what mom wanted. And it's, for us as healthcare workers, then legal, the hospital gets involved, or like, so even though you have that, make sure all your children know
Yep.
your wishes and know where it is and bring it in. Because when we start to code people, we keep going until we get that piece of paper.
Yeah,
So,
and
you know,
on that note with the documents, the old school way of thought from the lawyers was, we're keeping your original documents. I don't do that. Couple reasons. One, I'm hoping to retire one day, and I don't want to have to track everybody down with their original wills. And we do. We literally get emails from the kids at bar going, has anyone seen Edna Smith's will from 1987? No. But keep so I give everyone the original wills, but I also give everyone digital copies. Make sure as soon as you get the healthcare power of attorney, healthcare directive, you put a copy on file with your doctor. If it's with Virginia Mason, now it should go out. Same thing with Kaiser, whoever your provider is, so that you aren't in the event of an emergency running around trying to find a document. Power of attorney, you can have copies all over. Now the will, it's really important you have the original for probate, otherwise it's going to be presumed not to exist. We have one more there, and
Okay,
got to
we'll
fly.
go here since we got a mic here, and
Yep.
then Wayne can go back.
Mine just had to do with both documents. Do they require authentication endorsement by a council or county or state or?
They need to be, so I have them witnessed and notarized by 2 witnesses and notary. Washington State requires either. Some states, and I do that because some states require either notarization or witness. And if you're in Tennessee and need something, I don't want them to say, this was witnessed, not notarized, or vice versa. So I just do both. So that you don't need to worry about like official certification from the state, but you do need it from a notary and witnesses is what I said earlier.
Thank you.
One more, yeah.
This happened to a couple of friends of ours, and he went into the hospital, and his wife had durable power of attorney. However, one daughter, a devout Christian, claiming if she prayed hard enough, he would come out of it, and she kept him alive a lot longer than she needed to be. And she had one doctor say, I know what the problem is, and I'll take care of it. And he kept him alive even longer. And it was a horrible situation for him. He wouldn't stay in restraints and things like that. So what can we do with that? We're talking about a matter of faith here, interfering with this decision of a power of attorney.
Well, one, the person who has power of attorney, they shouldn't allow them to do
Well, the
that.
hospital wouldn't go along with it.
Well, that's an issue with the hospital, frankly. But there's also an issue with, I'm going to move forward on this one, the healthcare directive. That is what will then help, because then the healthcare power of attorney can say, he didn't want to live like that. He does not want to be connected to a machine, et cetera, et cetera. Now, look, if you have a healthcare directive, look at it, and if it's kind of bare bones, a lot of them just talk about artificial nutrition, hydration, and don't keep me alive, period. And that's kind of it. As you guys know, I'm married to a doctor, so we have some interesting dinner time conversations about end-of-life things. So for example, and I kind of alluded to this, what happens if you need amputation? Again, not a normal dinner time conversation. Healthcare directive, and it's kind of between my clients 50-50 across the board. Some say, hey, I don't want to die of sepsis, amputate me above the leg and give me a fighting chance. Others say, if I'm at that phase of my life, because again, this only kicks in if you're not competent, let me go, I do not want to be amputated. Totally a personal choice, but you're giving direction to your family about that. Same thing with kidney dialysis. That's another thing that pops up, and I've got that on my healthcare directive of, do you want dialysis at that phase of your life? Some say yes, as long as I can relate to my family still. Others say no, I don't want to be hooked up to a machine. Again, totally personal, but not something most people know about or talk about.
This is about durable power of attorney.
Yes.
Does it ever expire?
No, I mean, you can put an end date on it, certainly, or, you know, if people do them for, like, I'm going out on a trip for 3 months, I'm giving someone limited durable power of attorney while I'm gone. So no, it does not expire, but also pull that out, because if you've named one child, you know, for that, and same thing on the healthcare, and then they move to France, you don't want them making medical decisions from miles away, so.
I've had an interesting experience with that because I was at a credit union and they looked at it and they said to me, and my husband has dementia, they said, this is 10 years old. And I was like, so?
Yeah,
He
so.
did it when he had his brain, you know?
Yeah,
And they don't care.
yeah.
And the other question I have is it not accepted by certain entities like federal government, like the Veterans Administration? Because they say, we don't accept that.
Yeah, I've used the same form for 23 years and 22 years now. I've only had one issue, and that was where a client was, the husband was leaving to go work in Africa, and the day before they were trying to get the house refinanced, and the lender said, oh, we require very specific language that's not in here. We were able to redo it, but it was a weird thing specific to that lender. Legally, all of these, I mean, they absolutely should honor it, and when, the few times where they started not to, they say, you know, the client says, well, you're gonna get a call from my lawyer, and you'll be amazed what those scary words will do. And suddenly this document that they wouldn't accept becomes magically, you know, enforceable.
One, Phil, real quick.
Yep.
And then we'll keep going.
Okay.
Talking about the money angle, 10 years ago, when I was having one of my surgeries, I opened up another account and put my daughter's name on it too. So that, and now it was 10,000, but it's gradually, I've worked it up to 15,000. So that if something happens and she needs to have money right away to do something for me, she can get it.
Yes, now, that's what I was talking about before too, about the joint accounts with right of survivorship. Make sure that your will addresses that, because, yeah, no matter what, this will be probably the next slide, but, well, we'll get into trust in a second. I'll jump to what I was going to say about joint accounts. Anything with a beneficiary designation is not going to go through your probate, through your will. So, for example, if you say, I want my 2 kids to inherit everything 50-50, but you have a joint account with $50,000 on it, or you have a life insurance policy, or a retirement account that has some beneficiary that's different than what in your will, that's gonna trump what your will says. So go back, you know, you may have set up something 15 years ago and then got remarried. Well, who did he put on your account 15 years ago? Because even if your will says something different, all those other retirement account, financial companies are going to go with what your beneficiary is. So always double check that and don't just rely on what you have in your will. So,
Great,
yeah.
thank you. Can we, let's keep
Yeah.
going,
we'll keep rolling through
hold
this.
on to those questions, and
Okay.
we can always come back.
I'm gonna jump very briefly into trusts because that is the question I do get asked. I do get people saying, I wanna set up a trust. And so we go, well, what are your goals here? I don't wanna pay taxes and I wanna avoid probate and, you know, I wanna shelter everything I can from liability in case I could hit and kill a kid. They're not a get out of jail free card, otherwise we'd all put everything in trusts and it would be anarchy. It's not that. So a trust is basically a fiduciary arrangement in which a person allows a third party, the trustee, to exercise control over your assets on behalf of the beneficiary. Now, you can have revocable living trusts where you're your own trustee and your own beneficiary. The only real reason to do that in Washington, the real, you know, primary reason is to avoid probate, but as I indicated, that's not really a major issue. You're probably getting that from a friend from California. It's not going to shelter you from estate taxes. It's not going to shelter you from liability. So don't do that because you're your own beneficiary, you're your own trustee. The IRS is going to treat that as basically you. So if you're worth $5 million and want to avoid estate taxes, that's not going to work. So what do? So the first one up there is there. The other two are some sort of credit shelter trusts. I'm not going to go into a lot of detail about them. This is basically where your estate is starting to get above that 2.2 million threshold for individuals, and you're married, you can start putting things into the trust. Now, the problem with these sorts of marital trusts, and you know, on the bigger scale, if you're worth a lot more money and want to avoid estate taxes altogether, and you put things into an irrevocable trust, you can do that, but now you cannot be your own trustee. The trust is limited in terms of what you can do with it, and the kind of the apocryphal story I tell on this issue is I saw an attorney about 6 months ago down in court. I was like, hey, how's it going? He said, bad, I've got a really angry client. Why? Well, I set up an irrevocable trust for him 10 years ago. He asked me to be the trustee. Okay, sure, good client, why not? He's now come to me and he wants to do something with it. I don't know what he wants to do, buy Bitcoin, buy a house in Hawaii, whatever, but he can't do that under the terms of the trust. And I told him that, and he's really mad. He's like, what are you talking about? It's my trust, it's my money. It's not your money, it's the trust's money, and if I do what you're telling me to do, it's gonna vitiate the tax protections, and the ultimate heirs, your kids, could sue me if I do something wrong, because they're the ones that are meant to be protected. So you really do have to balance about the amount of money you're saving your estate when you die versus giving up a level of control. If you're worth $20 million, maybe it's worth it. If you're gonna save maybe 10, 20, 30, 50,000 in taxes, because you're at like 5 million as a couple, may not be worth it to give up that control. But again, if you're talking about those issues, go see a lawyer and they can advise you about the specifics. Just, that's the primer when people start hearing about trusts. We already talked about that, joint bank accounts there. Again, not included in probate, life insurance policies, designated retirement accounts, anything that's joint account there. So that kind of reiterates what I already talked about. So basically, to sum up, and then we can take questions, get the documents in place. You can try LegalZoom if you want. You get what you pay for. But see an estate planning lawyer. They may say all you need is a very simple set of wills, community property agreement, power of attorney, and you're done. They may say do a will, but we'll do a special needs trust or do marital trusts, and those only become effective when you die. You know, you don't have to transfer anything in. If you do go with setting up a trust immediately before you start transferring your assets, if you have a mortgage, talk to your lender. Because sometimes, and there's a federal law that if you're putting it into a revocable trust, it doesn't trigger your due on sale. But if you say, I want to put my house into an LLC, or I want to do this with it or that with it, the lenders, especially now with interest rates going up, if you've got a nice 2.5% interest rate, they want to make you refinance it. And they will find everything, they will look at titles. So before you start randomly doing that, get it in writing that they will not trigger the due on sale clause before you start transferring things out.
Just,
Kevin,
I
yeah.
told myself I wasn't gonna, but, here, hold on,
Yeah. And Kevin's also a retired estate planning attorney.
just to mention that if you have a trust, you still need to have a will.
Yeah.
A pour over.
Yeah. There's a thing called a pour-over will that basically says, if there's something that happens not to be in the trust at the time of my death, I'm giving my executor the authority to put it in the trust. So, and that's kind of one of the things I tell clients of, okay, we can do this, we can jump through the hurdles, put your house into the trust, your bank accounts into the trust, everything. 5 years from now, you're gonna buy a car. You're gonna forget, and you're gonna put it in your own personal name. Guess what? You get to open probate anyway, potentially. So, do it that way as you will.
I see Karen over there. Yeah.
I have two questions. One, I agree with what you said about the VA. They say you have to set up a designated person to be the person that they can talk to. They will not accept power of attorney, is what you're telling me. That's fine, because my dad is still able to do that. But I'm finding the same thing with DOD, and my mom is not, because she's incompetent. And they will not accept power of attorney. Do you have any advice on what you do?
In that
I mean, they're
case,
gonna come after me when she's no longer here to stop payment. But
yeah. What you then often have to do is go into court and essentially set up a guardianship, have the court appoint you as the official representative, if she's not competent. If she's competent, you can then, I guess, have them fill out the form. But from the incompetency standpoint, that's really what happens. And that's true if you don't have a power of attorney at all. and become incompetent, the family, in order to get control over the funds while they're still alive or make healthcare decisions, has to go into court and get a guardianship appointed. And I do, by the way, on my durable power of attorney, I say, if a guardianship ever has to become appointed for me, and that situation is, give an extreme example, I have bad Alzheimer's, I've lost track of the value of money, I go into bank accounts, take it out and start throwing it out on the highway, and the court, and the family says, we've got to restrict dad's ability to access money. Now they go into court because, obviously that can be ripe for abuse, so the court will investigate who wants to be appointed. But if you have 3 kids and all 3 are saying, I'll be the guardian, I at least like to say, in order of priority, here's who I want to serve as guardian. So the court has some direction.
Phil, can I just get some more clarification on this? So were you saying before though that in these cases with, what was it?
The Department of Defense.
They should honor it. I don't.
You're saying that, yeah, you have power of attorney, but DOD is not honoring it.
Will not honor it.
I think that's where you need to say that, I'll talk to my attorney.
Yeah, because I have a lot of clients who, they are working with DOD and with on various things. And
VA said the same.
And that's weird because they have
You've had
supplied
the
it,
same.
and they've, yeah, so.
So a lot of people are having trouble with that particular
Yeah.
part. This is helpful to know.
Yeah, it is.
But technically, from your
They should,
experience,
yeah.
they are supposed to. Okay,
Bill?
yes?
So right along that same line, when my father, and unfortunately it's California, but he had a revocable trust. The banks would not recognize that. And my sister had tons of problems dealing with medical and banks, and we had the durable power of attorney and all of that. And even though he had Alzheimer's, and the lawyer would not unrevoke the trust,
So,
and he was past the ability to do it, no one else recognized that.
well, so in the revocable trust, it does depend on the language. If the trust language allows for, and specifies that the attorney, in fact, power of attorney for any trustee also has authority, then they should honor it. But a lot of trust documents don't have that language. So then the bank says, technically, revocable living trust is its own entity, and you can't kind of daisy chain like, well, I'm Mike Haver's power of attorney, and he's the trustee of this trust, so therefore I have authority there. If the trust provides for that, you do. If it doesn't provide for it, the banks often won't. So make sure that if you have a revocable living trust.
Yep, it was all in
Wow,
there.
yeah,
And
okay.
it
And you
was
get a call
very
from the lawyer.
frustrating. So we couldn't access some of his VA benefits because you had to be so broke before they kick in.
Yeah,
But because there was money in his his revocable trust.
that's what I'm saying. They will treat it the same. So if you want to shelter it, and also there's look-back periods. When you start getting into like Medicaid planning, which is a whole different thing, you can't say, I'm going to probably go into a nursing home in 6 months, so I'm going to transfer everything out so Medicaid kicks in. There's a look-back period of 5 to 7 years.
Yeah.
So if that looks like a possibility, do it years in advance.
Okay, we got, I know 3-4 people lined up now. So Warren, go, we'll keep it, we got 15 minutes. Good.
Okay, now on power of attorney and durable power, say I made my sister power of attorney, can I, because she lives in Oregon, can I designate someone temporarily on the power of attorney and do, other things until she can ride and make a clear decision?
Typically, I don't like temporary ones because then it's a question, but the way you write powers of attorney is to say, I'm designating my sister as the primary, and if they're unable or unwilling to do it, then my best friend. And then it can be a simple email from her saying, I'm in Oregon, I don't know your medical condition, I'm declining to serve, and then the physicians should honor that, and it goes to the next person.
Okay.
Hi,
Julie
thank you
and then
for,
Kenny.
thank you for your time today, I appreciate it. You've touched base with this, but I have a question about, mine is a little bit of a mess, it's a list in my safety deposit box. I wanna clean it up, and when we wanna give certain personal items to certain people, I'm wondering if I should revise that and have just like
a paper, like one paper for one person, and then I can add to it and then connect it to my will, or what's the best way to handle the distribution of your assets that you wanna go to specific people?
So as long as you have a will that mentions the list, then it's kind of loosey-goosey, you know, about how to do it. There's not really a right or wrong way. I mean, I guess I would say, if you've got a list that's got 3 separate pages for 3 separate people, you can do it like that as long as you're signing it and attaching it to the will. But if there's just like a list floating around on a paper napkin somewhere that's not really signed by you, it's not really with the other documents, then it gets into factual things. And all of this comes down to, it's like the question I always get of, am I getting sued? I don't know if you're gonna get sued. I can tell you if you have a good legal case, but whether you're gonna get sued depends on the personality of the person on the other side. People have a horrible case, but are just jerks. They're aggressive jerks. You're getting sued. Some people who have a very good legal case, but people say, hey, my life's too short, I don't wanna wake up at 3 a.m. with a knot in my stomach, you're not gonna get sued from that person. But that's a separate question of, you know, do I have a good legal case? So same thing here. Is there gonna be a problem if this happens? It depends on your family dynamics. If you have one kid who you're not really leaving anything to, and they're omitted from your list of personal property, magically, they're gonna get into the house first, and that list is gonna disappear. You've got a problem. If everyone's on the same page, and you have a good cohesive family, you can do it on the back of a paper napkin, and everyone's gonna go, yep, that's what mom wants, no big deal.
And one more thing, when you do that list, and let's say you would add additional assets, you sign it, date it, and then you can add more to that list and sign and date it again?
Yeah, I typically tell people just have it on your computer, print it, so you're not rewriting it, and then when you change it, print out a new updated copy, sign and date it, and staple it to your will.
Perfect. Kenny, and then I think Mary's waiting. Yep.
2 quick things. Transfer on death
Yes.
papers.
Yep.
Are those more beneficial for certain circumstances?
So some people like doing transfer on death deeds, where basically you do a deed today, it's not actually in place, so I'm not giving you my property today, and it's fully revocable. At that point, when I die, you would go into the auditor's office with a copy of the death certificate, record that, and now it's triggered, and you don't have to wait through the whole probate process. That said, it doesn't mean you automatically get it free and clear. I mean, if I die and I've got $300,000 worth of gambling debt, and the creditors are saying, hey, we're coming after Haver's estate, and that house is the only thing in the estate, you've got to pay off that gambling debt because they'll get a judgment against it and go from there. So some people say, well, if I do this, does it avoid my debts? No, it doesn't. I mean, if you want to pay them out of other assets, you can do that. It does enjoy the benefit of not having to wait the 8 months or so for probate to be done and transferred by the time you've done the notice to creditors and all of that. So you do get access to it right away, but it's not like an immediate get out of jail. Yeah.
And then the last thing was just, any recommendations on like, where to store the documents and or have secondary copies or digital or what?
Yeah, so if, I always tell clients to put it in a home safe that's fireproof or a safe deposit box. I have had clients who just put it in a little manila folder, and then when the family's going through the house in a rush to dump everything, the will's gone, because we just tossed it. And that is a problem. In Washington, if we don't have the original, it's presumed that you destroyed it before you died, unless there's some other circumstance like a house fire where you go, the house burned down, that's why we don't have it, but we have a copy. And again, you know, I make digital copies, so I keep copies, so, you know, your lawyer, whoever that is, should have a copy, but keep copies as well. And it's not a bad idea to give copies of the powers of attorney to your powers of attorney and your executor, whoever that is, should get a copy. People do ask, well, should I give it to my kids? Depends what you're saying. If you're giving everything equally to both of them, it may not be a problem, but if you're gonna give something a little over here and more to that one, you don't wanna deal with the drama of this kid over here and going, Dad, what are you doing? You know, it's not fair. So oftentimes, yeah, parents don't give the kids a will because they don't wanna deal with whatever drama. Or why Nathan is my executor, as executor rather than me.
Yeah.
So.
That The question that I had was, did I hear you say that an attorney, that you should have your attorney keep the original?
No, I said don't.
You don't, you don't
The old
have.
school used to be doing that, and frankly, it was kind of, I don't wanna say a scam, but it forces the family to come back to that lawyer to do the probate. My philosophy is, if you wanna come back to me, you'll come back to me, but again, I may be retired, dead myself, so,
Okay.
you know.
Yes.
And
I had an attorney retired and had me come and get everything.
Yeah, that's the problem, and they factor in that.
And then the other thing, I think, what are the requirements for starting a trust?
Well, there again, it depends on
Any?
what type of trust do you wanna do, irrevocable or revocable, what are your
Uh-huh.
goals of the trust? You know, really, the only requirements are, you're competent, you have to have a trustee, could be yourself depending on the type of the trust, and who the beneficiaries are, and then you need to fund it. So many people come to the lawyers and set up a trust, but really where the issue is you've gotta fund it, so you have to put all your bank accounts into the trust, all your retirement, you know, So,
Everything.
yeah, I mean, if that's your goal, avoid probate.
Oh, thank you.
Okay, thank you, Mary. I see, let me just,
And I can stay later if we don't get to all the
Yeah,
questions.
I just, since we just talking about trusts, I had a question.
Yeah.
Real quick, if you have a trust because you're from California, but you've lived up here now for 18 years and you've not had it removed, we need to do that, correct? Or how do you get rid of a
So there's
trust?
a couple of things. One, if you only have Washington assets, like you've sold everything in California, and you
right.
come to me and say, Phil, I've got a California trust, what should I do? I'd say dump it.
How do you do that?
It's a one-page revocation,
Okay.
and then I would say just do simple wills. Some people come up with the California trust, and before meeting with me, start putting assets into the trust, in which case you probably want to convert the California trust into a Washington trust. And that's not that difficult, it just takes some
But if we just had stuff in that trust when we lived in California,
Yeah.
we can just zip off. Okay. Oh, sorry, over here.
So we're doing a goose chase, and we were wondering if we could take a photo with you and everyone in this room. Yeah.
Oh, yeah, while a goose chase with the youth, absolutely. Everybody, where do you want to? Here.
Here, I can just stand here and take a photo.
Okay. Smile, everybody.
Okay, thank you.
Oh, no, we have one more question.
Yeah, one more question.
Yeah, could we, just like don't.
Is it about estate trusts?
What's a scrap?
Okay, a snap selfie? Oh, a sacrament selfie. What's a sacrament? It's a means of grace. Means of grace. Baptism or the Lord's Supper. Where would you get a picture? Go to the altar and get a picture. Okay, I think I probably wasn't supposed to tell you. All right, no. She told you to ask. Okay, I see, way to go, girls, good job. Bill hasn't had a chance yet, and then we'll do a quick one.
Just on the list, this may help Karen a little bit, but on the list of power of attorneys, given that we live in a military community, I did not see a military power of attorney. And this could be why DOD is not recognizing it.
Right.
DOD is very specific on military power of attorney, and they will not recognize power of attorney unless it's a military power. Is that accurate? Do you have experience with that?
Honestly, I've heard clients saying they've had some issues, but then they've eventually gotten it through. So to get a carte blanche, they just didn't accept, like, my powers of attorney. I haven't heard that.
They say they have their own form, and you have to have it declared through your lawyer, subject to the VA.
Okay.
The VA they both have a different name for it.
So
That's odd, yeah. It may be-
they've gone rogue. They want their own form. That's important for everybody to hear, that we're hearing a lot of people who have had struggles with that. Bill?
If you have a piece of property that has a house on it that you're living in, and you have more than one child,
Yeah.
and you want to leave it, but you want it to eventually go to one of the children, as long as the agreement that she would then pay the other children their portion of the value of the property. How should you handle something like that?
the way I handle it, wills are written specific to general, so I'd make a specific bequest to this child, and it also depends if there's a mortgage, because you may say that, I want my kid to have this, but they don't qualify to, you know, and there are some laws that say, hey, if a child inherits, they can keep paying on the mortgage, but they may not be able to afford to do that. But aside from the mortgage issue, it just says, I'm giving my house to my son, Bob Smith, comma, provided that an equalization payment will be made out of either the rest of the estate to the other kids for the value, or provided that he pays them the equal value if there's not enough assets. And then what you do at probate is have the house appraised at what the actual value is, not tax assessed, actual appraisal. And a good lawyer should have, you know, kind of standard language of how to deal with that. So you can address it that way.
Yeah, that value can change when you do.
Right.
It's date of death value.
Okay, right there. Oh, go ahead, Dion.
This is just how times have changed. When my mother died, she had I'm the oldest of four, she had a piece of blue notebook paper, and she had put 4 lines, you know, made 4 columns. We all knew this existed, and she listed what she wanted each of us to have when she died. And we followed it to the letter, and I've always said that my parents could be very proud of us because we did exactly what they wanted. No arguments.
No arguments, yeah.
They got a little bit more than me because they were all in Michigan, and it was the logistics of getting it out here. But nevertheless, I've always thought that they would be very proud of us.
And I'm gonna use that comment. We're going to Carol and then here, and then we're gonna probably have to
Just
quit.
really quick, back to the health directive. There's a booklet that's available, it's called The 5 Wishes. Does that count as your health directive?
Yeah, I mean, the health directive is just, it's a personal document meant to convey what you want to have happen. So you can get them from the hospital, I mean, you can pull them off the internet. Just some are specific, some are very general. So just read what you want. If you can, you know, edit it yourself, like if you're very concerned about ventilation versus artificial nutrition, you know, tubes, put in what you want, you know, and like some people really care about the amputation thing. I don't want to be amputated. Address that. If there's other issues, put it in. But if you just go with the basic form, you're going to be stuck with whatever generalized.
Be specific. Lisa, I'm sure, has a.
That 5 wishes is not valid in all states, so it says on the document on the back, it should say what states it's valid in. I just had another quick comment. Nobody likes surprises. So if you name someone as your healthcare power of attorney, you should be talking with them about what you want, how you want to see the end of your life happen, and what you want. Because if they can't fulfill those wishes that you want, you don't want them as your healthcare power of attorney.
Very helpful, Lisa.
Just as a pointer on financial power of attorney with automated banking, electronic banking, if they live in New York, that's usually okay. For a healthcare power of attorney, you probably, if at all possible, I mean, if all your kids live out of state and you want to name them, do what you can. But ideally, you want someone who's more local. So, you know, a medical decision based on your condition that's deteriorating isn't being made remotely from Kentucky. So just, you know, take that into account.
One more?
What if you don't have $2 million and you have nothing as assets to leave to put in a will? What kind of a will, like, would I have if
I would just do a simple will. I mean, if you have assets, but if you have 0 assets at all. I mean, in Washington, there's a thing called a small estate affidavit. If you don't own real property and your estate is worth less than $100,000, you don't need probate. Just whoever your heir is, to the extent they're inheriting everything, like you literally die with just owning a car, they can do a small estate affidavit, go to DMV and transfer the title, or go to the bank if it's got $20,000 in it, and you're certifying mom died with less than $100,000, and no real estate, no probate's being opened. I'm the sole and only heir, and the bank is entitled to rely on that, and they'll release the funds to you. But it's got to be under
Excellent.
$100,000.
Hey, this has been really helpful. Almost feel like we need another hour, right? But I hope this has got you thinking, again, from a stewardship standpoint, how do I be a good steward of the gifts God has given me? We will keep this conversation going. We'll be looking at spiritual stuff. We'll be looking at other medical stuff. We're going to have folks from the fire department, other people coming. So just keep coming back, and we're going to help you in this regard. Let's thank Phil for his great expertise.
The last comment we
Yeah,
make before we go is simply, getting a will done is not scary, it's not too time consuming. Get it done before the inevitable happens.
Perfect.
We don't want to miss it.
That's it. Get it done. I see it all the time, folks. So does Phil. Get your will done. Doesn't matter how old you are.
Things change, and so I just, when I finally made that phone call, I just really felt like, okay, so much, like I really just felt so good, and my daughter talked to me
Hey, if you want the slides that you saw, send me an email and I'll forward those slides to you. Just send Pastor Bill at silverdalelutheran.org. If you send me an email, I'll attach them to you. Or if enough people are asking, we'll make PDFs and get it to you a different way. So we can get you the slides. Phil gave us permission to do that.
It's hard. And the lawyer we had Kevin Fair.